Greetings, I'm Shireen Nisha, and today I'll be critically analyzing whether the maxims equity will not perfect an imperfect gift and equity will not assist a volunteer contradicts a settlor's intention. It has long been established that for a trust to be fully constituted and for a gift to be effective, legal title must vest in the transferee. Two famous equitable maxims govern this area of law. The first one, equity will not perfect an imperfect gift. This suggests that if a donor fails to comply with required legal formalities, the gift will be deemed imperfect and equity will not come into the assistance of the donee. The second maxim, which is directly linked to this equity, will not assist a volunteer. This means that unless the intended beneficiary has provided consideration, they will not have rights and will be considered a mere volunteer. Therefore, just because a donor who fails to complete a gift already has legal title in that property vested in them, that will not suffice to demonstrate that the donor should be deemed to be a trustee of the property instead. A volunteer is a person who has not given consideration. The issue we should consider here is whether or not failure to make a complete, perfect gift can be rescued by deeming trust to have been created over the property. Strictly speaking, beneficiaries under trust will not have given consideration, but equity assists beneficiaries once there has been valid declaration of trust in their favor. For a trust to be effectively established, the settlor must present the three certainties of intention, subject matter, and object when declaring the trust, and the trustees must obtain legal ownership to the trust property. Consequently, if these requirements are not met, no legal trust will be established. Nevertheless, there are circumstances in which the trust was not properly established, but there was still a valid trust. In the leading case of Milroy against Lord, a voluntary deed executed by Milroy purported to assign 50 shares to Samuel Lord. Lord was supposed to hold those shares on trust for Milroy for life and in remainder for some of his relatives, including the claimant. The problem was that the legal title in the shares was never vested in the trustees. What happened was that no transfer of the shares was registered in the company's books as was required by the formalities for transferring shares under the law at that time. The result was that Milroy remained the legal owner of those shares, and Lord acquired no legal title in them so as to make him properly constituted trustee. This meant that the claimant did not acquire his remainder interest in those shares. The claimant was seeking to establish that a trust had been declared and had equitable propriety rights in the shares. However, the Court of Appeal had given two reasons to why a trust had not been created in this context. Firstly, an ineffective transfer did not constitute a declaration of trust in itself. And secondly, the settlor must have done everything which was necessary and effectual. The Milroy case was encapsulated in the statement of Lord Justice Turner, which mentioned that in order to render a voluntary settlement valid and effectual, the settlor must have done everything which, according to the nature of the property comprised in the settlement, was necessary to be done in order to transfer property, and render the settlement was necessary to be done in order to transfer property and render the settlement binding upon him. But in order to render settlement binding, one or other of these modes, outright transfer, declaration of self-trustees, or transfer of properties to a third party as trustee must, as I understand the law of this court, be resorted, for there is no equity in this court to perfect an imperfect gift. Therefore, the court is adamant that a frustrated intention to make a gift will not be saved by reinterpreting it as an intention to create a trust. This strict rule ensures an element of certainty in the law. Following Milroy, the court in Refry refused to impose a trust. In this case, the settlor delivered share certificates to trustees, but at the time, share transfers had been approved by the Treasury. The settlor died before receiving approval. If we look at the Malaysian case following the rule in Milroy, which is the case of Lee Ng Teh and others against Teh Tiang Siong and another, Justice Gill stated that after referring to Milroy, the first defendant did nothing more than make a gratuitous promise to donate land. so that there was no question of any incompletely constituted trust having arisen, and therefore the action against him must fail. However, Justice Gill further went on to say that applying the exceptions of propriety estoppel, it is clear that the second defendant, having allowed the school to be built on their land, must be deemed to hold such land subject to the equity that they shall allow the school building to remain there indefinitely. The court's refusal was based on the possibility that the transfer may have been rejected or details may have been required. Whilst the Milroy decision is the general rule, circumstances have arisen which have caused the courts to create exceptions to the Milroy principle. To contradict a settlor's intention, the issue arises in relation to the situation in which the donor has done everything necessary to transfer title in the property to another person, but where that outright transfer or gift has nevertheless not been completed. The question is, if the donor has performed all the acts necessary to be performed by her to complete the making of a gift, should the donor have been deemed to hold that property on trust for the intended donee from the moment of completing the necessary acts? It was held in re Rose that if the donor has done everything necessary to make a gift, then equity will deem an equitable interest in the relevant property to have passed automatically, even if the donee is a volunteer. This principle is an exception to the rule that equity will not assist a volunteer. It turns on the concept of having done everything necessary, which was lifted from the judgment of Lord Justice Turner in Milroy. In Re Rose 1949, the testator had purportedly made bequests of shares in favor of a man called Hook, provided that Hook had not received those shares by transfer before Rose's death. Mr. Rose had executed a voluntary transfer in respect of the shares which he had given to Hook. This transfer form constituted everything required of Rose to transfer the shares, but was not a completion of the transfer because there was further formalities to be performed by the company. The issue was whether the transfer of shares to Hook had taken effect under the ineffective inter vivos transfer form or under the transfer of the will. However, Justice Jenkins held that because Mr. Rose had done everything in his power to divest himself of the shares in question, the shares should be treated as having been passed to the legatee by the transfer and only perfected by registration. The court took the view that the equitable interest should be deemed to have passed because Rose could not have renegade on the transfer after the form has been completed and sent off. In Re Rose 1952, the registered owner of shares executed two share transfers, one in favor of his wife, absolutely by way of gift, and the other in favor of two people, including his wife, on trust. The shares were in a private company which empowered the board of directors to object to transfer of shares. Again, the transferor had completed all the formalities required of him. The argument for the Inland Revenue was that there was no transfer until ratification, as provided by company law, and that there could be no suggestion of an express trust having been created because that would be to give effect to the intended bequest by means not intended by the transferor. The Court of Appeal in Re Rose 1952 approved the decision in Re Rose 1949 and held equitable interest in the shares had been transferred as soon as all formalities which was required had been completed. The decision of Re Rose was a move away from Milroy and step towards effectuating the donor's intention rather than frustrating the transaction. The operation of the rule infringes the general principle in Milroy by assisting volunteers, allowing equity to deem a transfer complete in equity before legal title has passed. The case of Maskal against Maskal is an example of the operation of the rule in Re Rose. The settlor intended to transfer his house to his son. He filed in a transfer form and gave it to his son to complete parts required by him and sent the form to the stamp office. The Court of Appeal held that the settlor had done everything in his power to transfer title, and the transfer was complete when he delivered the form. Although it was the son's responsibility to send it to the land registry, the father had done everything in his power. Only acts of third parties remained, which were beyond the settlor's control. In T. Choitram International SA against Pangarani, a man lying on his deathbed sought to declare inter vivos trust over his property. The settlor's intention was that he would be one of 9 trustees over that property. However, the dead man failed to transfer legal title in the property to all 9 trustees, and as a consequence, under the ordinary law of trust, the trust would not have been validly constituted. Nevertheless, Lord Brown Wilkinson held that although equity will not assist a volunteer, it will not strive officiously to defeat a gift. This case is unique and only applied where the settlor is himself a trustee. In the case of Kwan Tek Ming and others against Liu Sam Lee, 1963, the court held that applying the re-rose principle in the case of a transfer of land, the transferee, as from the date of the signed transfer form, becomes the beneficial owner of the land, although the legal title will not vest in him until the transfer is duly registered. The sons had the locus standi to bring this action. In summary, the requirements set out in re-rose cases are that the settlor must use the correct method of transfer and have done all that they could to complete the transfer. The Court of Appeal in Pennington against Wayne expanded the ambit of the rule by introducing the concept of unconscionability, which, if satisfied, equity will declare transfer complete before all formalities are completed. The settlor must have irrevocably put the transferee in a position to complete the transaction. Here, the donor had intended to make an immediate gift and the donee had been informed and agreed to it. However, due to the unconscionability test, it renders it almost impossible for practitioners to confidently advise clients undertaking property transfer in order to avoid action or to advise clients if they are faced with an imperfect transfer. General consensus amongst academics such as Morris and Halliwell is that Pennington has overstretched the boundaries. Furthermore, Lord Justice Arden did not speak of any limits of the court's discretion and used an umbrella term of must depend on the court's evaluation of all relevant considerations. This gives the courts a wide discretion to perfect imperfect transactions. Halliwell calls this an untruly beast, indicating that the Pennington case is potentially dangerous if not subject to limitations. It is logical to conclude that Pennington seriously undermines the maxim that equity will not assist a volunteer by perfecting imperfect gifts. There are also exceptions to the maxim which may be capable of perfecting an imperfect gift, which is through the rule of strong against bird, fortuitous vesting, donatio mortis causa, and propriety estoppel. The rule in strong against bird dictates that where a deceased person intended to make a gift of property without making a complete gift, if that person is named as the executor of the deceased estate, the gift is deemed to have been completed. There are 3 requirements for the rule to operate. Firstly, there must be an intention to make an immediate gift. Secondly, the intention must continue until death. Finally, the donee must obtain legal title in the property in the capacity of either as executor or administrator. However, there exists considerable debate about whether this rule should be applied to administrators at all. This can be seen as harming the property, as the beneficiary has not provided sufficient consideration of benefiting the property. However, this exception can complete an incomplete gift, as was the case of Rees Stewart 1908. The case of Rees Sheikh Hassan bin Abdullah Al Joffrey 1953 had also relied on the rule of strong against bird, as well as the case of Lee Hun Ki against Yo Sing Huat 1965. Fortuitous vesting is where a failure to perfect the intended recipient's title may be cured if they obtain legal title through another route. This will usually occur because the intended recipient of a gift is also the personal representative of the transferor's estate. On the transferor's death, legal title to all their property will transfer to their personal representative to administer their estate. If their personal representative was also the intended recipient of an imperfect gift, this gift may be perfected on the death of the transferor. In the case of Raleigh Will Trust 1964, a woman received property from her deceased father's will trust after her mom died. The trustee of the will trust was also the trustee of the woman's marriage settlement trust. The question was whether the trustee held the woman's property as trustee of the will trust or trustee of the marriage settlement trust. It was held that the property was to be held on trust for the marriage settlement. Under a clause of the settlement, the wife declared that she held any existing property on trust for the marriage settlement, and this would include the revisionary interest in her father's will trust. Thus, the woman held more than a mere expectancy. Propriety estoppel is a further exception to the rule. This remedial doctrine aims to compensate a claimant who has suffered a detriment caused by reliance on a representation by the defendant. As in the case of Pascoe against Turner 1979, where a man left his wife and said she can keep the house, leading her to maintain and repair the house. In the eyes of the law, the wife acted to her detriment. She was entitled to some compensation. The law employs a broad construction of what type of conduct is required to succeed in a claim for propriety estoppel. In Re Basham, mere oral evidence of a gift of a house by the daughter's stepfather was enough for propriety estoppel to be found. The detriment coming from caring for the stepfather when he was ill. The Malaysian case of Teng Chung Wan Sendirian Berhad against Yap Yok Ki Sendirian Berhad has applied propriety estoppel to protect plaintiff's equitable interest in the existence of a lease of unspecified duration over the buildings, as well as the case of Amar Singh, Anak Lelaki Sundar Singh and others against Jibanjit Kaur, daughter of Sohan Singh, 2010, which was recognized as propriety estoppel. Donatio mortis causa, otherwise known as a gift in contemplation of death, was sometimes a gift given by a person that expects or contemplates that they may die soon. These are typically made by people who are seriously ill or about to undergo a major surgery, and by people who are about to travel, fearing the worst may occur. To make a gift surrounding this nature, the person in question would have to give up all control to the recipient and only become the absolute owner after death. This was invoked by the method set out in Cain against Moon. There needs to be some intention shown to give up dominion of the ownership. An example would be the case of Sen against Hadley 1991, where someone was on their deathbed and the partner was by them at the time. In this case, the settlor is on their deathbed, intended to transfer their house to their partner, showing intention to give up dominion. In conclusion, this area of law has been affected by significant and lengthy development. Initially in Milroy, no discretion whatsoever was granted. This ensured a stable and reliable law, but of course it did not lead to the fairest outcomes. Essentially, fairness was sacrificed to ensure that the courts are not overwhelmed and the law remains unambiguous. Rose and Choitram still did not endorse or demonstrate unfettered discretion, as judges in both cases remained cautious of the maxims and the ruling in Milroy. They departed from this very cautiously, only placing minor emphasis on conscionability and combining this with technical legal justification during departure. However, in Pennington, a complete departure was made from both the maxims and Milroy, and the judges enjoyed unfettered discretion. This has far-reaching negative consequences, despite providing the opportunity for judges to reach a fair outcome. Courts will quickly become overwhelmed, and there would be no certainty in the law, and formalities are likely to become redundant. Although this may be a persuasive argument in sympathetic circumstances, the law must apply a strict balance between logical reasoning and emotional decisions. Here, emotion and fairness must play second fiddle in order to uphold the entire framework of this area of law. There is no doubt that whilst conscionability cannot be used as the sole determining factor, it should still play a part. Therefore, the law should attempt to establish a more neutral balance similar to that seen in Choitram in order to ensure fair decisions are upheld where the law can afford to uphold them. Thank you.